Section 8. Types of contract structures. Contract law in today's market. Understanding contract structures in real estate transactions. In the previous section, we explored the legal classifications of contracts, including valid, void, voidable, and unenforceable agreements. While those classifications describe the legal status of a contract, contract law also recognizes different structural forms that describe how obligations are created and performed. Understanding these structures is important for real estate professionals because contracts can vary depending on how the parties promise to perform, how the agreement is expressed, and whether the obligations have already been completed. These structural differences help courts determine how a contract should be interpreted and enforced. Real estate transactions often involve multiple contract structures operating simultaneously. For example, a purchase contract may be a bilateral, express, and executory contract at the time it is signed. As the transaction progresses and the parties complete their obligations, that same contract may eventually become an executed contract once the closing occurs and the property transfers ownership. Bilateral contracts in real estate. The most common type of contract used in real estate transactions is the bilateral contract. A bilateral contract involves two promises exchanged between the parties. Each party promises to perform a specific obligation. In a typical residential purchase transaction, the buyer promises to pay the purchase price, and the seller promises to transfer ownership of the property. Because both parties have made promises to perform, the agreement is considered bilateral. Most real estate purchase agreements, listing agreements, and lease agreements fall into this category. Once the promises are exchanged and mutual assent exists, the contract becomes binding on both parties. If either party fails to perform their promised obligation, the other party may pursue legal remedies such as damages or specific performance. Unilateral contracts and performance conditions. A unilateral contract differs from a bilateral contract because only one party makes a promise, while the other party accepts the offer through performance rather than a promise. In other words, the contract becomes binding when the requested action is completed. Unilateral contracts are less common in traditional real estate sales, but still appear in certain situations. For example, a property owner might offer a reward for information leading to the recovery of stolen property. The owner promises to pay the reward, but the contract becomes binding only if someone performs the requested action by providing the information. Another real estate-related example may involve a broker offering a referral fee to another agent if that agent introduces a buyer who successfully purchases a property. The promise to pay the referral fee becomes enforceable only when the condition, producing the buyer who closes on the property, is satisfied. The key feature of a unilateral contract is that performance creates the binding obligation rather than a reciprocal promise. Express contracts versus implied contracts. Contracts may also be classified based on how the agreement is communicated. An express contract is one in which the terms of the agreement are clearly stated, either verbally or in writing. Real estate contracts are almost always express contracts, particularly because the statute of frauds requires agreements involving the sale of real property to be in writing under ARS, paragraph 44-101. Written purchase agreements, listing agreements, and lease contracts are all examples of express contracts because the parties explicitly state their intentions and obligations. An implied contract, on the other hand, is created through the actions or behavior of the parties rather than through explicit words. Courts infer the existence of a contract based on the conduct of the parties involved. For example, if a property owner consistently allows a tenant to occupy a property and accepts rent payments without a written lease agreement, a court may determine that an implied lease agreement exists based on the conduct of the parties. Although implied contracts can be legally recognized, they can also create uncertainty and disputes because the terms are not clearly documented. For this reason, real estate professionals strongly encourage clients to use written express agreements whenever possible. Executory versus executed contracts. Another important distinction involves whether the obligations under a contract have been completed. This distinction is described using the terms executory contract and executed contract. An executory contract is a contract in which some or all of the obligations have not yet been completed. Most real estate purchase agreements are executory contracts at the time they are signed because the buyer has not yet paid the purchase price and the seller has not yet transferred ownership of the property. During the escrow period, the parties work toward fulfilling the obligations outlined in the contract. The buyer may obtain financing, complete inspections, and secure insurance, while the seller prepares the property for transfer and provides necessary disclosures. An executed contract occurs when all obligations under the contract have been completed. In a real estate transaction, this typically occurs when the transaction closes, the buyer pays the purchase price, and the deed is recorded transferring ownership of the property. Understanding the difference between executory and executed contracts helps real estate professionals determine when contractual obligations still exist and when the transaction has been fully completed. Promissory estoppel and reliance damages. In some situations, courts may enforce a promise even if a formal contract does not exist. This concept is known as promissory estoppel. Promissory estoppel occurs when one party makes a promise that another party reasonably relies upon, and the relying party suffers harm as a result of that reliance. For promissory estoppel to apply, several elements are typically required: a clear promise made by one party, reasonable reliance on that promise by another party, a foreseeable expectation that the promise would be relied upon, financial harm or loss resulting from the reliance. For example, imagine a buyer who sells their current home after a seller verbally promises to sell them a property, but later refuses to proceed with the transaction. If the buyer relied on the promise and suffered financial losses as a result, a court may award reliance damages even if a formal contract was never finalized. Promissory estoppel is not commonly used in standard real estate transactions because written agreements typically exist. However, the doctrine illustrates the importance of clear communication and documented agreements in professional real estate practice. Online discussion. 1. Question: why are most real estate purchase agreements considered bilateral contracts? Answer: most real estate purchase agreements involve mutual promises. The buyer promises to pay the purchase price, and the seller promises to transfer ownership of the property. Because both parties promise to perform obligations, the contract is considered bilateral. 2. Question: why are written contracts strongly recommended instead of relying on implied agreements? Answer: written contracts clearly document the rights and obligations of each party and reduce the risk of misunderstandings or disputes. Implied contracts rely on behavior rather than written terms, which can create uncertainty about what was actually agreed upon. 3. Question: what happens when a real estate purchase contract becomes an executed contract? Answer: a purchase contract becomes executed when all obligations under the agreement have been completed. In real estate transactions, this usually occurs at closing when the buyer pays the purchase price and ownership of the property is transferred to the buyer.